some of your telephone calls about fighting the insurance companies in a moment, but you know, some lawyers in the area take a lot of heat for the amount of money they receive after a successful verdict. However, most folks don't fully understand the system. Personal injury attorney Melissa Detchmendy explains contingency fees in tonight's legal brief.
Under a contingency fee arrangement, a lawyer agrees to take a case without any money up front. In return, the lawyer is entitled to a percentage of the amount of money collected if the case is successful, usually around 1/3. Lawyers who take cases on a contingency fee take a big risk. These attorneys must front the cost of litigations themselves. Sometimes this can amount to thousands or even millions of dollars. If the case is lost, the lawyer is paid nothing. That's right, nothing. The contingency fee system ensures that injured people who couldn't otherwise afford a lawyer are able to have their day in court. It's a system that allows blue-collared injured people to hire attorneys to take on the richest and most powerful corporations in the country. Eliminating the contingency fee would effectively strip the keys to the courthouse from the average citizen. That's your legal brief for tonight. I'm attorney Melissa Detchmendy of the Vic Hawk Law Firm. Back to you.
Thank you, Melissa, and we're rejoined by Melissa's colleagues, Vic Hawk and also Reed Sanders from the Vic Hawk Law Firm. Our first call of the morning is Tina from South Carolina. Tina, how are you?
I'm fine.
Great. We understand you have a medical situation as it relates to insurance. Is that right?
Yeah, that's true.
What type of procedure do you need?
Well, I need a stem cell transplant, but when I filed it, my insurance, they won't cover it because they said it's experimental based on my condition. I have an autoimmune.
Tina, do you have your television audio turned up? If you might be able to turn the volume down, we'd appreciate it.
Okay. I will.
Okay. And go ahead, Tina. What did the insurance company say to you? Why are they refusing your coverage?
They're refusing my stem cell transplant because they say it's experimental, because it's fairly new that they discovered that it works for all systems. So they're saying that they won't cover it. They'll cover a standard stem cell, but not for scleroderma. So you think I need to get a lawyer to fight that?
Does she need a lawyer to fight it?
Well, Reed?
Well, the problem here is that they're classifying it as experimental, and for for it to be covered, that probably you would need a note from a doctor saying that it wasn't experimental, that it was necessary. But there's probably a list of exclusions and that kind of thing in your policy that'll say what is covered and what is not covered. So I think that you could go to that or have an attorney look at that, and then you may be able to find your answer there.
I think if you get a letter from the insurance company explaining why they're denying the coverage, in other words, they say this particular procedure is experimental. What you can do is demand from your insurance company a written explanation, and then go to your doctor, and show your doctor that explanation. And many times your doctor can provide the medical authority to demonstrate it is not experimental, and you are entitled to the coverage, and can cite other supporting authority to establish that it's not experimental. You see this a lot with insurance companies, especially on the healthcare side, because if there's a gray area when you deal with an adjuster, they're going to err on the side of the insurance company and not on your side. And the only way you're going to get them to change is to pin them in, box them in, showing that you have authority for your entitlement to that coverage. And if you take those simple steps, you should be able to get the coverage.
And when you're talking about that note, writing your insurance company a letter to say basically, why are you or why aren't you paying for this? There's 60 days they have to respond to that,
That's right. Yeah, 60 days. And I would send it certified mail and make sure you have a copy.
Right. Always make sure you have a copy of anything you send to them, especially, certified is the best way to do it, so you have a date and shows that they received it. Also, if they tell you anything, like we talked about earlier, if they tell you anything or promise you anything on the phone, ask them to send that to you in writing or email it to you or whatever, so you can have a hard copy of that.
Well, next up, Irma from Augusta, who went through an accident and would like to go to court. Irma, are you there?
Yes.
Okay. Where did the accident occur?
It happened a year ago.
Mm-hmm. And you're from Georgia. Where did this occur?
In Oklahoma.
Okay.
And they sent me a letter that says now that I got to either file it in court, but told me I had to get an attorney in Oklahoma. But from the beginning, they told me I could come back to Augusta, go to the doctors down here because it broke my leg in 3 places and my ankle in 3 places. They told me I could do everything down here. Now they're trying to tell me to get another lawyer.
Have you had all your treatment? Have you finished treating?
No.
Okay. And that you said the accident was in Oklahoma?
Yes, sir.
And do you know where the defendant resides?
Yeah, Oklahoma.
Okay. Well, I mean, you wouldn't have to. Go ahead.
They said it was a liability case.
Mm-hmm. On who was at fault, pretty much. Well, basically, in this kind of situation, you wouldn't have to have an Oklahoma attorney. You could have, a Georgia attorney do the case for you, but they would have to have special permission to practice law in Oklahoma. That case is going to have to be filed in Oklahoma because the defendant's there and the accident's there. So, to answer your question, you may get a Georgia attorney, but you may be better off getting an Oklahoma attorney. But I know you probably don't know anybody in Oklahoma or know an attorney in Oklahoma. So, we can help you with that and try to get you, referred to a trial attorney that can take care of you out there.
And another thing to be very careful of in your situation is maybe the Oklahoma statute of limitations is just 1 year.
Right.
And some states have just 1 year statute of limitations. So if you're approaching a year, you really need to get with a good trial lawyer right away, and we'll be happy to help you if you just call tomorrow at 722-3500.
Well, you've seen the commercials about Flo and the lizard and Mayhem and all the national commercials, and you may be wondering, why is one policy a lot cheaper than the other? Well, Vic and Reed will explain, I guess, how to go shopping for your insurance on the other side of the break. Stick around. You're watching News 12 Law Call. The telephones again, where Joseph from Augusta, Richmond County joins us with a question about insurance and his manufactured home. Hello, Joseph. How are you?
All right. About yourself?
Oh, doing just fine. Thank you so much for staying up. We sure do appreciate it. What specifically would you like to know about your insurance policy?
Okay. It's insured with the improvements for actual replacement value, not actual cash value. It's had additions, a garage and an extra room, utility room, and there's a back porch and a roof over on that. And I don't know if my dad ever got building permits for that, and it's insured for actual replacement costs. And whether it was building permits issued or not, if I'm paying the premiums and say fire or tornado, would the insurance company still have to honor the agreement as it was written?
Go ahead, man.
Yeah, I would say absolutely. They have to follow the terms and conditions of their policy. If you're paying for replacement costs, then as long as you've disclosed what the nature of the building, the additions to the building, any improvements to the building, if you have your personal items insured for replacement costs, as long as you've disclosed what is contained in your home, then you should have coverage. And if you look at it and you see that your replacement costs provision says, well, up to a maximum of $25,000, and that's not enough, well, then you need to call your agent and up your coverage. The failure to get a building permit is not going to affect whether you're entitled to the coverage that you paid for.
Yeah, I think the main thing is, like you said just a second ago, is you got to look at the maximum value of that coverage, and is that going to be enough to cover all the extra things that have been done? Because if it's not, it could save replacement value, but if it only has a coverage of $10,000 and the replacement value is $100,000, then you really, in actuality, don't have coverage.
And one of the things that you should do for that kind of coverage is do a video, whether it be on your cell phone or some other type of device. Do a video of your home, outside, inside, each room, and show everything that you have in your home, because that's where the fight's going to be when there's a fire or when there's a tornado.
Good point. No, the pictures never lie, right? They're right
I
there.
agree.
Well, we have a call on the other side of the river in South Carolina. Jessica joins us from North Augusta. Good morning, Jessica.
Good morning.
Well, share with us what happened with a family member in a car accident.
I allowed my daughter and son-in-law to take my car on a trip in December. And on the way home, they were hit. And the young lady apparently was driving a rental car, which was insured, but she begged them not to put it on the insurance.
Right.
So she said she would take care of it personally. We got the 3 estimates. We wrote letters and emails. Everything was certified. She got the letters. We haven't heard anything from her. And so the last letter is an offer for her to break the payment up into 2. And what we have said is if we don't hear from her by a certain date, we're possibly going to consider getting help with an attorney.
Sure.
My question is, what is the statute of limitations? Because this happened in December. I don't want to drag this out for another year. My car's got to be fixed.
Sure. Well, where did the accident take place?
In Jessup, Georgia.
Okay.
Yeah.
Okay. And you live in South Carolina?
I do.
Okay. Well, if it depends on where the driver, the defendant in this case would be, and I would assume it would be Georgia. So that you'd have a 2-year statute on that case. So, but as far as you're talking about property damage. Attorneys it's a little bit tougher to help with property damage just because it's not as it's more cut and dry, and you can really basically do it by yourself. What you can do is look at the Kelley Blue Book value and some other things online and see what the car's worth, and you can file with the insurance company for the property damage. Was anybody hurt in the accident? I'm not sure if she's still with us, but if there was somebody hurt in the accident, then you'd have a personal injury claim. And you can go ahead and settle a property damage claim and still have a personal injury claim out there. So, but you need to go ahead and get with the insurance company right away, because it sounds like the lady's not going to pay for it, and file a property damage claim immediately. And then, like I said earlier, if you have a personal injury claim, you can file that later as well.
Well, we wanted to, do we have time for one more call? Okay, super. Rebecca from Jackson, South Carolina. Rebecca, how are you?
I'm doing all right.
Okay. Your son has some medical issues, and we guess the insurance won't cover the procedure. Real briefly, what's the procedure?
To be circumcised.
Okay. How old is your son?
He is, by his due date, he is only 2 months. He was due February 5th, but he was born in 26 weeks, 5 days. We have rescheduled his circumcision 3 times because the insurance company not wanting to take care of him. And circumcise it, they're saying it's not a need to, it's not a medical emergency nowadays, but it can cause infection, and I'm tired of fighting this. And right now, he was born November 4th. He is actually 5 months.
Right.
And I need to have this done before he is able to feel the pain.
Sure.
And he's on a heart monitor and an apnea machine, and they're constantly wanting to fight it.
Rebecca, we addressed this a little bit earlier in the show, and what you've got to do is you have got to send a letter to the insurance carrier telling them that you want to know why they're not paying, and put it in writing. And then when they put it in writing, give them 60 days, and if they don't pay or don't authorize it, then you need to come to one of us, and we can help you out with that. But I would go ahead and get it done and incur the medical bill in the interim, and then deal with the insurance company later on.
Vic, thanks so much, as well as Reed. Next Sunday, bankruptcy. We hope you have a wonderful week ahead. Happy Easter, everyone.
Easter.
Yeah. Thank y'all for calling.